I stood at the edge of my land, heart sinking as bulldozers ripped into the rich soil that had cradled my family for 5 generations. The morning sun caught the glint of metal machinery as they slashed roads through what was once our thriving farmland. Construction crews buzzed across the eastern stretch, hammers pounding and saws whining as luxury cabin skeletons sprouted like stubborn weeds after a spring downpour. Men in hard hats pored over blueprints while trucks rumbled in, dumping load after load of materials. What threw me off wasn't just their bold trespass, it was their unshakable confidence, as if they owned the place, not a flicker of guilt or doubt in their eyes as they ignored me completely. I stayed quiet, hands clasped behind my back, a faint smile tugging at my lips. The Homeowners Association from neighbouring Mountain Vista Estates had made a colossal blunder, one that would come back to haunt them, and I wasn't about to tip my hand just yet. I'm Judge William Harrington, retired after 27 years on the state Supreme Court, with 15 years prior as a constitutional law professor specializing in property rights and land use. The irony of this scene wasn't lost on anyone who knew my history, especially since the HOA was building on my land, leaning on an easement law I'd penned nearly 4 decades ago. That legislation, hailed as a gold standard for balancing development with property rights, had been my proudest achievement. Yet it seemed the Mountain Vista HOA thought it could bend my own rules to suit their whims, or maybe they hadn't bothered to dig into who they were crossing. This 300-acre gem, farmed by my family since my great-great-grandfather settled here in 1887, had once been the county's breadbasket, yielding corn, wheat, and soybeans for thousands. My father worked it until his last breath, his hands forever marked by the earth. I chose law over the plow, but selling our legacy was never an option. 5 years ago, after retiring, I let much of the land rest, letting nature reclaim it as a tribute to over a century of toil. Little did I expect that quiet would be mistaken for weakness by eager developers. Mountain Vista started as a modest enclave of 50 homes a decade back, perched on the ridge above my farm, but its HOA had grown bold, snapping up smaller plots nearby until 6 months ago when they overstepped. The first red flag was a certified letter, its cold legal jargon chilling me as I read it at my kitchen table, my coffee going cold beside me, stunned by their nerve. Which city of the United States are you watching from? Drop a comment and share with us if you have any confrontation with the HOA. We will narrate your story on our channel. The letter stated that Mountain Vista Estates would be exercising historic easement rights over what they called an unused access corridor on my property. The letter referenced a survey from 1923 that supposedly indicated a county access route through what was now my eastern field. The Homeowners Association claimed this gave them the right to construct a limited access road for the benefit of community expansion. The letter closed with the presumptuous sentence, "Construction will commence on March 1st. Please ensure all personal property is removed from the designated corridor by this date." I called the number listed on the letterhead that very afternoon. The conversation was brief and unsatisfying. The woman who answered identified herself as Diane Wilcox, president of the Mountain Vista Estates Homeowners Association. Her voice was clipped and confident as she explained that their legal team had thoroughly researched the matter and determined they were within their rights. When I attempted to explain that I was the former judge who had helped draft the very easement laws they were invoking, she cut me off with a dismissive laugh. "With all due respect, sir, we have a team of attorneys who are well versed in current property law. If you have concerns, please direct them to our legal department in writing." Then she hung up, leaving me staring at my phone in disbelief. I decided to visit the Homeowners Association office in person. The following day, The Mountain Vista States Clubhouse was an impressive structure of stone and glass designed to showcase the panoramic views that gave the development its name. The reception area was staffed by a young woman who listened politely as I introduced myself and requested a meeting with Mrs. Wilcox or any member of the board. "I'm sorry, sir," she said with practiced sympathy, "but the board only meets with non-residents by appointment, and I'm afraid we're booked solid for the next 3 weeks." She slid a business card across the polished granite counter. "You're welcome to email our community liaison with your concerns." I took the card and left without argument. There was no point in making a scene. Not yet. Over the next several weeks, I documented everything. I took photographs of survey markers that appeared overnight on my property. I recorded the dates and times of preliminary visits by engineers and surveyors. I made copies of the original easement documents for my land along with the legislation I had helped craft decades ago. I even pulled out my old legal notebooks from my time drafting the state easement laws, which clearly outlined the limitations and requirements for establishing valid easements. The Homeowners Association had failed to meet even the most basic prerequisites for claiming an easement on my property. There was no historic right of way, as they claimed. The 1923 survey they referenced had been superseded by a 1947 county development plan that explicitly recognized all of my family's acreage as private farmland without any public access requirements. 2 weeks before their announced construction date, I sent a formal cease and desist letter to the Homeowners Association Board and their legal counsel. I included copies of the relevant documentation and cited the specific sections of the law that protected my property rights. I clearly stated that any attempt to build on my land without proper legal authority would constitute trespassing and property damage, both criminal and civil offence. I signed it with my full title, Judge William Harrington, Retired State Supreme Court. I thought surely this would give them pause, would make them reconsider their reckless plan. I was wrong. March 1st arrived with the rumble of heavy equipment. I stood on my porch at dawn, watching in disbelief as a caravan of construction vehicles turned off the main road and onto my property without hesitation. They had cut through my fence during the night, creating an entrance wide enough for their few bulldozers and trucks. The lead vehicle bore the logo of Vista Construction, a subsidiary of the development company that managed Mountain Vista Estate. I walked out to meet them, my cease and desist letter in hand, but was stopped at the makeshift gate by a security guard in a company uniform. "Sorry, sir, this is an active construction site. No unauthorized personnel beyond this point." When I explained that this was my property, he squinted at me suspiciously. "I just follow orders, sir. My paperwork says this access road is being built on Homeowners Association land. If you have an issue, you'll need to take it up with management." I could have called the sheriff that day. I could have sought an emergency injunction. But after decades in the legal system, I knew that sometimes the most effective strategy is to allow your opponent enough rope to hang themselves. So instead, I watched and documented. I took photographs as they cleared trees that had stood since before my birth. I recorded video as they graded the land and poured gravel for a road that cut nearly half a mile into my property. And most importantly, I noted every violation of the easement law that I had helped write. Violations that were now accumulating, like storm clouds on the horizon. The construction progressed with alarming speed. Within weeks, the access road was completed and they began marking out plots for what appeared to be vacation cabins. Glossy brochures appeared online advertising Mountain Vista Wilderness cabins with exclusive forest access and panoramic valley views. The cabins were being pre-sold to wealthy out-of-state buyers looking for weekend retreats. None of these potential buyers were informed that the development was being built on contested land. None were told that the seller lacked clear title to the property they were purchasing. By early April, the foundation for the first cabin was poured. I walked to the edge of my property, what was left of it, and approached the site supervisor, a burly man with a weathered face and suspicious eyes. "You realize this is private property?" I said calmly. "There is no valid easement here. What you're doing is illegal." The man sighed as if dealing with a particularly slow child. "Look, mister, I just build what I'm told to build. The homeowners association has all the permits and approvals. If you've got a problem, take it up with them." He turned his back on me and barked orders at his crew, dismissing me entirely. I left without another word, my resolve hardening with each step back to my house. That evening I received an unexpected visitor. My neighbour of 20 years, Harold Jenkins, knocked on my door just after dinner. Harold owned a farm adjacent to mine on the west side, well away from the construction, but close enough to see what was happening. "Bill," he said as I invited him in, "I saw you talking to those construction fellows today. Is it true? Are you letting the Mountain Vista folks build on your east field?" The disbelief in his voice was evident. I poured us both a cup of coffee and explained the situation, showing him the fraudulent documents and my ongoing documentation of their trespassing. Harold's weathered face darkened with each detail. "This isn't right, Bill. First, they tried to pressure the Wilkinsons into selling last year, and now they're just taking your land. Someone needs to stand up to these people." I assured him that someone would, but in my own time and my own way. Harold left with a promise to alert the other neighbouring farmers about what was happening. Within days, I began receiving calls and visits from concerned neighbours, many offering to help fight the homeowners associate. I thanked them all, but maintained my patient approach. This wasn't just about my land anymore. It had become about protecting the entire farming community from predatory development practices. As word spread about the dispute, local media began to take notice. A reporter from the county newspaper contacted me, asking for an interview about what she called the brewing land war between Mountain Vista Estates and the historic Harrington Farm. I politely declined, explaining that I preferred to let the legal process run its course without public commentary. The reporter was persistent, however, and published a story anyway based on public records and interviews with neighbours. The article, which appeared on the front page of the Sunday edition, painted a sympathetic portrait of a multi-generational farm under siege from wealthy developers. Mrs. Wilcox responded with a letter to the editor, dismissing the article as emotional sensationalism and reiterating the Homeowners Association's claim to a legitimate easement. Progress cannot be halted by sentimentality about unused farmland. She wrote, "Mountain Vista Estates is bringing economic growth and prosperity to a region that has been stagnant for decades." Her condescending tone only served to galvanize public opinion against the development, with several subsequent letters supporting my position and criticizing the Homeowners Association's aggressive tactics. The next day, I drove to the county courthouse and spent hours researching the permits the Homeowners Association had filed. What I found was disturbing but not surprising. They had submitted falsified documents showing a pre-existing easement on my property. They had doctored survey maps to make it appear that the access corridor had been established decades ago. And most egregiously, they had submitted a forged letter of consent supposedly signed by me, granting permission for limited development on the eastern section of my farm. The fraud was blatant and extensive. I made copies of everything and added them to my growing file of evidence. As I was examining the forged consent letter more carefully, I noticed something that made me smile despite my anger. The signature, while a reasonable facsimile of my own, contained a telling error. Throughout my career, I had developed the habit of adding a distinctive flourish to the final N in Harrington, a small loop that connected back to the O. It was a subtle detail noticeable only to someone familiar with my authentic signature, but absent on the forged document. This small oversight would be yet another piece of evidence when the time came. I also discovered that the Homeowners Association had applied for and received special tax incentives from the county, claiming they were rehabilitating abandoned agricultural land for community benefit purposes. They had submitted photographs of a small overgrown section of my property, deliberately avoiding the areas I still maintained to support their claim of abandonment. The tax breaks they received reduced their development costs by nearly 30%, making the cabin project even more profitable at my expense. On my way out, I stopped to chat with several former colleagues who still worked at the courthouse. I didn't mention my ongoing issue with the Homeowners Association, but I did casually ask about recent developments in easement disputes. The conversation was illuminating. Apparently, Mountain Vista Estates had been involved in 3 similar situations in the past 2 years, bullying small landowners into surrendering property rights under threat of expensive legal battles. One elderly couple had sold their family orchard for well below market value after the Homeowners Association threatened them with a decade of litigation. Another farmer had granted an actual easement for a much smaller access road after the Homeowners Association's lawyers presented him with potential legal costs that exceeded his annual income. The pattern was clear. Mountain Vista Estates had perfected a strategy of legal intimidation against vulnerable property owners. They had simply miscalculated when they decided to target a retired judge with extensive knowledge of property law and the resources to fight back. Throughout the spring and into the summer, I watched as cabin after cabin rose on my land. The Homeowners Association moved with remarkable efficiency, completing roughly 1 cabin per week. They installed utilities, cutting trenches for water and sewer lines, erecting electrical poles, even laying fiber optic cables for high-speed internet. All without permission, all without compensation, all in direct violation of the law. They cleared century-old oak trees to improve the views, diverted a small stream that had flowed through my property for generations, and even installed a series of decorative fountains fed by groundwater, pumped from my own aquifer. The environmental damage was as distressing as the property theft. I began taking daily walks around the perimeter of the construction, maintaining a careful distance, but making my presence known. Some of the workers started to recognize me, and I could see uncertainty in their eyes as they noticed my methodical documentation. One young electrician approached me during his lunch break, speaking quietly and glancing over his shoulder to ensure no supervisors were nearby. "Sir, some of us have heard rumors that this might not be Homeowners Association land. After all, is that true? Are we working on your property without permission?" I confirmed that they were indeed trespassing, but assured him that my dispute was with the Homeowners Association leadership, not with the workers who had been misled. The next day, I noticed that the young man and 2 others were no longer at the site. Whether they had quit on ethical grounds or been removed for speaking to me, I never discovered. By August, they had completed 50 cabins and sold 43 of them to unsuspecting buyers. The cabins were not large, roughly 800 square FT each, but they were luxuriously appointed with high-end finishes and smart home features. Stone fireplaces, floor-to-ceiling windows facing the mountain views, hand-scraped hardwood floors, and custom cabinetry made from timber harvested from my own property. According to their website, each cabin sold for between $300,000 and $450,000, depending on the location and view. The development was being marketed as an exclusive retreat for wealthy professionals from the city, a place to disconnect from urban stress and reconnect with nature. The irony of destroying natural habitat to create a wilderness association was apparently lost on the Homeowners Association marketing team. As the Kavanaugh sales accelerated, the Homeowners Association began hosting weekend open houses, bringing prospective buyers onto my property in luxury shuttles. They set up a lavish hospitality tent where Mrs. Wilcox personally greeted visitors, champagne in hand, extolling the virtues of mountain living and the exclusivity of their community. From my kitchen window I could see these gatherings. Wealthy strangers walking on my family's land, planning their vacations in homes built on stolen property. Completely unaware of the legal storm that was brewing, I took particular note of the real estate agents involved, adding their names to my ever-growing documentation. They too would eventually need to answer for their role in this fraud. In September, I received another letter from the Homeowners Association. This one informed me that due to the overwhelming success of the Wilderness Cabins initiative, they would be expanding the development to include an additional 50 units, pushing even further into my property. The letter also mentioned plans for a community recreation area featuring a pool, tennis courts and a clubhouse, as if to add insult to injury. The letter closed with an offer to name the clubhouse Harrington Hall in recognition of my family's historic contribution to the community. I couldn't help but laugh at the audacity. They were destroying my property and offering to commemorate my family name on the building that would stand as a monument to their theft. I continued my patient documentation as autumn painted the surrounding forests in brilliant reds and golds. The construction never slowed, even as the weather turned colder. By early December, they had completed their 100th cabin and sold most of them to eager buyers looking for a Christmas retreat in the mountains. The Homeowners Association hosted a grand opening celebration complete with a ribbon-cutting ceremony and champagne reception. From my kitchen window, I could see the twinkling lights of the new development, a cluster of luxury cabins where corn had grown just 1 year before. It was time to act. The morning after their celebration, I put on my best suit, the one I had worn for my final day on the bench, and drove to the office of Harper Wentworth and Associates, the most respected law firm in the state. The receptionist recognized me immediately, her eyes widening as I approached her desk. "Judge Harrington, it's an honor to have you visit us, sir. How may I help you today?" I explained that I wished to speak with Janet Harper if she was available. The receptionist made a quick call, then directed me to take the elevator to the 14th floor. The law firm occupied 3 floors of the city's most prestigious office building, with panoramic views of the mountains where my farm and now the illegal cabins were located. As I stepped off the elevator, I could see the firm's success in every detail. The original artwork on the walls, the handcrafted furniture, the hushed atmosphere of serious legal work being conducted at the highest levels. Several associates nodded respectfully as I passed, recognizing me from their law school days or from my time on the bench. Janet's corner office reflected her senior status in the firm, with floor-to-ceiling windows and shelves lined with legal texts, including, I noticed, with satisfaction, several that contained opinions I had written during my judicial career. Janet Harper had been one of my most promising students nearly 20 years ago and had gone on to build a reputation as a fierce litigator specializing in property rights. Her face lit up with surprise and pleasure when her assistant showed me into her office. "Judge Harrington, what an unexpected honor. Please sit down. Can I offer you some coffee?" We spent a few minutes catching up on professional gossip before I placed my thick folder of evidence on her desk. "I need your help, Janet. I'm about to go to war." Janet leaned forward, instantly alert. She had always been perceptive, able to sense the weight of the situation without needless explanation. "This sounds serious. Property dispute." I nodded, appreciating her quick understanding. "The most brazen I've encountered in 40 years of law," I replied. Janet glanced at her computer screen, checking her calendar, then pressed the intercom button on her desk phone. "Margaret, please clear my schedule for the next 2 hours. Judge Harrington and I have important matters to discuss." She turned back to me with the focused expression I remembered from her days in my classroom. "All right, Judge, start from the beginning." For the next 2 hours, I walked her through the entire situation. I showed her the original letters from the Homeowners Association, My responses, the photographs and videos documenting the construction, the falsified permits, and the forged consent letter. I explained how the Homeowners Association had violated not just general property law, but specific provisions of the easement legislation that I had helped draft. By the time I finished, Janet was shaking her head in disbelief. They built 100 cabins on your land without permission, and they forged your signature on official documents. Judge, this isn't just a civil matter anymore. This is criminal fraud and conversion on a massive scale. She tapped her pen against her legal pad, thinking quickly. We need to file for an emergency injunction to halt any further construction, and then we'll prepare a comprehensive lawsuit against the Homeowners Association, its board members, individually, and the development company. They've made a very expensive mistake. The holiday season passed in a flurry of legal activity. Janet and her team worked tirelessly preparing multiple filings while coordinating with the district attorney's office regarding the criminal aspects of the case. I spent Christmas alone in my farmhouse, listening to the sounds of celebration coming from the illegal cabins on my property. I was not angry anymore. I had moved beyond anger to a cold, calm certainty about what was to come. The Homeowners Association had built their entire development on a foundation of fraud and arrogance. Now that foundation was about to crumble beneath them. On January the 2nd, the first business day of the new year, Janet filed our lawsuit in state court. The complaint ran to over 200 pages detailing every violation of property law, every fraudulent document, every illegal act committed by the Homeowners Association and its representatives. We sought immediate restoration of my property, actual damages for the destruction of agricultural land, punitive damages for the willful and malicious nature of their actions, and criminal prosecution for fraud, forgery, and conversion of property. The filing made headlines in the local paper. Retired Supreme Court judge sues Mountain Vista Estates over massive property theft. The article included a quote from Mrs. Will Cox, the Homeowners Association president, dismissing the lawsuit as a desperate attempt by a confused old man to extract money from our thriving community. Her dismissive tone would come back to haunt her very soon. Our case was assigned to Judge Regina Maxwell, a respected jurist known for her no-nonsense approach to property disputes. The preliminary hearing was scheduled for January 15th, barely 2 weeks after our initial filing. I spent those 2 weeks preparing with Janet and her team, reviewing every detail of the case, anticipating every possible defense the Homeowners Association might attempt. Meanwhile, word of the lawsuit had reached the cabin owners, many of whom were now desperately trying to contact the Homeowners Association for explanations. The association's response was a form letter assuring owners that the lawsuit was frivolous and would be swiftly dismissed. They could not have been more wrong. The day of the hearing arrived with a winter storm that blanketed the county in 6th in of snow. The courthouse was unusually quiet as I walked through the familiar halls, nodding to former colleagues and accepting their well wishes. Janet met me outside the courtroom, impeccably dressed and radiating confidence. "They've brought in reinforcements," she whispered as we took our seats. "Markson and Bell from the Capitol, heavy hitters in real estate law." I glanced across the aisle at the Homeowners Association's legal team. 5 attorneys in expensive suits surrounded by boxes of documents and looking uncharacteristically nervous. Mrs. Wilcox sat behind them, her face set in a mask of indignant certainty. Our eyes met briefly, and I offered her a small, knowing smile. She looked away first. Judge Maxwell entered the courtroom precisely on time, and the proceedings began with the usual formalities. The Homeowners Association's lead attorney, Richard Markson, spoke first, presenting what he called incontrovertible evidence of a historic easement on my property. He displayed the survey from 1923, pointing out a dotted line that supposedly indicated a county access route. He presented affidavit from several elderly residents who claimed to remember a community path through the Harrington farm many decades ago, and he argued passionately that the Homeowners Association had acted in good faith based on this historical evidence and my apparent abandonment of active farming. Throughout his presentation, I maintained a calm, almost amused expression. I had heard these arguments before. I had anticipated and refuted them when drafting the easement legislation 40 years earlier. When it was Janet's turn to speak, she began not with the evidence of fraud as I had expected, but with my credentials. Your Honor, before we address the specific claims in this case, I believe it's important to establish the unique expertise of my client. Judge William Harrington served on this state Supreme Court for 27 years. Before that, he was a constitutional law professor specializing in property rights and, most relevantly, to today's proceedings. Judge Harrington was the primary author of the State Easement Act of 1982, the very legislation that governs the claims being made by the defendant. A murmur ran through the courtroom. Across the aisle, I saw the blood drain from Richard Marson's face as he hurriedly conferred with his colleagues. Judge Maxwell raised an eyebrow, clearly intrigued. "Is this correct, Counselor?" she asked Markson. "Are you citing easement law to the judge who wrote it?" Markson attempted to recover, his voice slightly less confident than before. "Your Honor, with all due respect to Judge Harrington's distinguished career, the law evolves through interpretation and application. Our understanding of the Eastman Act has been shaped by 40 years of case law and precedent. It was a good effort, but Janet was prepared. Indeed, it has, Your Honor, and in those 40 years, there has not been a single successful claim of prescriptive easement that failed to meet the 4 essential criteria established in the original legislation: continuous use for the statutory period, open and notorious use that is adverse to the owner's interests, and use that is without effective challenge from the rightful owner." She turned to face the Homeowners Association's table directly. "The defendants cannot establish even one of these criteria, let alone all 4 as required by law." For the next hour, Janet methodically dismantled every aspect of the Homeowners Association's claim. She presented the 1947 County Development Plan that superseded the 1923 survey. She showed affidavit from neighboring landowners stating that there had never been public access through my farm in living memory. She displayed aerial photographs of my property taken every decade since the 1950s, showing continuous agricultural use with no evidence of any access road or community path. And then she moved to the more damaging evidence, the falsified permits and the forged consent letter. Your Honor, the defendants did not merely misinterpret the law, they deliberately and systematically violated it through fraud and forgery. They were not acting in good faith, they were acting with the knowledge that their claims would not withstand legal scrutiny. Judge Maxwell listened intently, asking occasional pointed questions of both sides. I observed her technique with professional admiration. She had a masterful way of cutting through obfuscation with precisely targeted inquiries. When Markson attempted to suggest that the Homeowners Association had made good faith efforts to contact me before beginning construction, Judge Maxwell stopped him mid-sentence. "Counselor, are you suggesting that a single certified letter followed by ignoring the owner's cease and desist response constitutes good faith negotiation?" Marson stammered something about industry standards, but Judge Maxwell had already moved on to her next question. Throughout the hearing, I noticed several cabin owners sitting in the back of the courtroom, their expressions growing increasingly concerned as the evidence of fraud unfolded. These were the unwitting victims of the Homeowners Association's scheme. People who had paid hundreds of thousands of dollars for vacation homes built on land to which the sellers had no legal right. I felt a momentary sympathy for them, but reminded myself that they would have their own legal recourse against the Homeowners Association. My responsibility was to my family's legacy and the land that had been entrusted to my care. When the presentations concluded, Judge Maxwell looked directly at the Homeowners Association's legal team. "Councillors, I'm deeply troubled by the evidence presented here today. At minimum, we have a case of unauthorized construction on private property. At worst, we have criminal fraud on a scale rarely seen in this courthouse." Her voice remained measured and professional, but there was no mistaking the underlying anger in her words. The documentation presented by the plaintiff appears to show a systematic effort to appropriate valuable land through deception and forgery. If these allegations are proven in the main trial, the consequences will extend far beyond civil remedies. She turned to address me directly. Professional courtesy from one judge to another. "Judge Harrington, I recognize the restraint you've shown in allowing this situation to develop to its current state. Many in your position would have sought immediate injunctive relief at the first sign of encroachment." I nodded in acknowledgement of her insight. My strategy had been deliberate to allow the Homeowners Association to commit fully to their illegal course of action before holding them accountable. By permitting them to complete the entire development before taking legal action, I had ensured that the full extent of their liability would be clear and undeniable. Judge Maxwell seemed to understand this perfectly, her slight nod conveying professional respect for the legal strategy I had employed. Her ruling was swift and comprehensive. "I am issuing an immediate injunction against any further construction or sale of properties in the disputed area. I am ordering a full survey to be conducted at the defendant's expense to determine the exact boundaries of the unauthorized development, and I am referring the evidence of document falsification and forgery to the District Attorney's Office for potential criminal prosecution." She fixed the Homeowners Association representatives with a stern gaze. "Given the extraordinary nature of this case and the clear risk of asset dissipation, I am also freezing the Homeowners Association's accounts pending the outcome of the full trial. This court will reconvene in 30 days to assess compliance with these orders and to set a schedule for the main proceedings." With a decisive bang of her gavel, the preliminary hearing was adjourned. The next 30 days unfolded like a slow-motion collapse of a house of cards. The District Attorney's Office moved quickly, filing criminal charges against Mrs. Wilcox and 3 other board members of the Homeowners Association for fraud, forgery, and conspiracy. The development company that had built the cabins filed for bankruptcy protection, claiming they had been misled by the Homeowners Association regarding land ownership. And most significantly, nearly 80 cabin owners filed a class action lawsuit against the Homeowners Association, alleging that they had been sold properties without valid titles. The financial implications were staggering, with each cabin selling for an average of $375,000. The total fraud amounted to over 37 million. News of the case spread quickly through legal circles, attracting attention from property rights advocates nationwide. Several law schools requested permission to use the case as a teaching tool for their property law classes. I received calls from former colleagues and students, all expressing disbelief at the audacity of the Homeowners Association and support for my legal battle. Through it all, I maintained my quiet dignity, refusing to give interviews or engage in public discussions about the ongoing case. This was not about publicity for me, it was about justice and the restoration of what had been wrongfully taken. When we returned to court 30 days later, the atmosphere was markedly different. The Homeowners Association's legal team had been reduced to just 2 attorneys, both looking considerably less confident than before. Mrs. Wilcox was notably absent, having been advised by her criminal defense attorney to avoid making any statements related to the civil case. Janet presented our updated filings, which now included a detailed remediation plan for returning my property to its original condition. The cost of this remediation, as estimated by environmental and agricultural experts, would exceed $12 million, a figure that caused audible gasps in the courtroom. The Homeowners Association's attorneys weakly suggested that some accommodation might be reached that would allow the cabins to remain while providing fair compensation to me for the use of my land. Judge Maxwell cut them off mid-sentence. "Counselor, let me be perfectly clear. Your clients built luxury homes on land they did not own without permission based on fraudulent documents. There is no scenario in which this court will reward such behavior by granting retroactive access rights. The only question before us is the extent of the damages and the timeline for remediation." The final ruling came down 3 months later after numerous hearings and failed settlement attempts. Judge Maxwell's decision was unequivocal and far-reaching. The Homeowners Association was ordered to remove all structures from my property within 6 months, to restore the land to its original condition according to expert specifications, and to pay $22 million in combined actual and punitive damages. The board members who had approved the fraudulent scheme were permanently barred from serving in any homeowners association or property management capacity. And in a particularly fitting twist, Judge Maxwell cited my own legal writings in her decision, noting that the clarity and foresight of Judge Harrington's original legislation leaves no room for the creative misinterpretation attempted by the defendants in this case. The dismantling of the Wilderness Cabins development began in early summer, almost exactly 1 year after construction had started. I watched from my porch as crews carefully deconstructed each cabin, salvaging materials, where possible, and removing all traces of human habitation from my land. The process was methodical and thorough, overseen by environmental consultants to ensure that no lasting damage was done to the soil or the natural watershed. By autumn, the last cabin had been removed, and the restoration of the natural landscape had begun. Where luxury vacation homes had briefly stood, native grasses and wildflowers were now taking root, the first step in a comprehensive revision plan that would eventually return the land to its natural state. The criminal cases against the Homeowners Association leadership proceeded in parallel with the civil remediation. Mrs. Wilcox and the development company's CEO both received substantial prison sentences for their roles in the fraud. Several lower-level employees received probation in exchange for their testimony about the systematic nature of the deception. The class action lawsuit filed by the cabin purchasers was settled for an undisclosed amount, though industry rumors suggested it had bankrupted the insurance company that had unwisely provided coverage to the Homeowners Association. The entire affair became known in legal circles as the Easement Massacre, a cautionary tale taught to first-year law students about the dangers of ignoring property rights and the consequences of fraudulent development. As for me, I returned to my quiet retirement, planting wildflowers where cabins had once stood, and watching the gradual healing of the land that had been in my family for generations. When a journalist from a national legal magazine finally convinced me to give a brief interview, I offered only one quote about the entire ordeal. They tried to rewrite the law. Unfortunately for them, I wrote it first. The statement was widely circulated in legal publications, often accompanying discussions of the case that had become a landmark in property rights jurisprudence. I took no pleasure in the downfall of those who had attempted to steal my land, but I did feel a deep satisfaction in the vindication of the legal principles I had spent my career defending. The law, when properly written and fairly applied, remains our most powerful tool against those who would use wealth and influence to take what is not rightfully theirs.